I wanted to make a video to give my opinion about the recent case that came out concerning the Voting Rights Act of 1965. There's been a lot of hoopla about it. Many in the Black community have deemed it to be um, just a death nail to their right to vote, and that there's going to be a return to the Jim Crow system that disenfranchised them for many, many years. But in my general opinion, I think that's not true. I think that the Supreme Court was right in how it went about uh, deciding this case, and that the right decision was made, and we're going to move forward and have a better country. Now, let me give you the backstory here, so then you can understand what I'm thinking here about this whole issue. Now, the right to vote for African Americans was essentially established with the 15th Amendment. So this was ratified in 1870. And the 15th Amendment gave African Americans the right to vote in Section 1. But in Section 2, Congress had the right and the ability to enforce the 15th Amendment through appropriate legislation. So that's the 15th Amendment. But after Reconstruction, so 1877, all the way up to 1965, the South was utterly defiant in allowing African Americans the right to vote, right? In particular, the Ku Klux Klan, right, which was created around 1865. And the Ku Klux Klan, really its stated mission, from really when you look at its actions, was to completely deracinate the Black vote. And it went all throughout the South to completely intimidate Blacks from voting, to take away Black senators, Black congressmen. They would brutalize them, beat them, even kill some of them, right? To utterly deracinate the vote. And it was very successful in certain counties, especially York County in South Carolina, places like that, right? Very successful. But even after the federal government, through Ulysses S. Grant, completely trashed the KKK, I believe in the early 1870s, you had white supremacist groups or even white individuals who had a white supremacist ideology in them went out of their way to suppress the Black vote. One famous example is the Wilmington Massacre in 1898, where there was a fusionist Republican mayor who was running the city, and Blacks were going to vote for a new mayor, new legislature in the city, and the whites in the city did not want that to happen. So what they did was they instigated the Blacks and tried to say that they were going to have an insurrection against the whites in the city. And so the whites in the city who were Democrat just gutted the Black political polity in the city. They just trashed the mayor. The mayor had to leave. The Democrats took over. It was pretty it was authoritarian. It was an anti-democratic regime. And the Blacks in the city left their homes, left their property, and many of them didn't return for decades, right? And so that tells you the mentality of many in the South. They did not want Black people to vote, and they would use any means necessary to do it. Any means necessary. If it had to go about killing people, they do it. And so Congress is facing this attitude, this aggressive attitude from the South, and it has to use aggressive means in order to try to corral this force. And the aggressive means was a litany of legislation that was passed in the 1960s. So the first real monumental act was the 24th Amendment. So this is the prohibition against poll taxes, right? So that was one. Then you had the Civil Rights Act of 1964, which pretty much said that establishments cannot discriminate on the basis of race, gender, sex, what have you, right? And then you have the 1965 Voting Rights Act, which pretty much is that issue right now, is states cannot go about discriminating against Blacks when it comes to their right to vote. But the issue with that was that the Voting Rights Act, in many aspects of it, was unconstitutional. And you saw this with 1966 when South Carolina sued Nicholas Kassenbach, who was the U.S. Attorney General at the time, saying that Section 4 of the Voting Rights Act of 1965 was unconstitutional. Now, what was really the reason? The reason why that they say it was before states can enact any legislation regarding their voting system, they had to get clearance from the U.S. Attorney General to make sure that they weren't discriminating against African Americans and other minorities. However, this is totally unconstitutional because states have complete sovereignty over their legislative process. They have complete sovereignty over how they go about passing laws. Now, if a law obviously is unconstitutional, they would be sued. But if a law is against the federal government and the federal law, then the supremacy clause would apply, where the federal law would preempt state law. So that's how our system worked. But Section 4B of the 1965 Voting Rights Act completely went away with that, and it didn't apply that standard. And so it was unconstitutional. But the Warren Court in Kassenbach said that no, we are applying the Constitution here because we are enforcing Section 2 of the 15th Amendment. We have the jurisdiction, we have the right to go about making sure that blacks have the right to vote because racism for over 100 years has taken away their right to vote. And we can't tolerate that anymore. And they pretty much won. They prevailed. However, the pre-clearance requirement was only for 5 years at the time, if I'm not mistaken. So there's a duration, there was an end date to this because it was unconstitutional. But then, obviously, the next court after that, they extended it for another 5 years and then another 7 years and then 25 years. But needless to say, that issue was always really at play was the constitutionality of the Voting Rights Act of 1965, right? Shelby v. Holder rendered Section 4B as unconstitutional for the obvious reasons, because it went against our federalist system, where states have sovereignty over their legislative process. So it was the right move. Now you come here to this lawsuit here, when that was just recently decided by the Supreme Court, Louisiana v. Callis. Is the issue here is whether or not Louisiana violated the Constitution by adding an additional majority minority district for black people. Was this gerrymandering unconstitutional? And the Supreme Court in that case decided that it was. And the reason why they decided what it was because the 1965 Voting Rights Act did not require for states to draw another district for black people. That you actually were not complying with the Voting Rights Act when you were doing this. So it's not necessary. So since it's not necessary, and since race is a prevalent factor in how the state went about drawing this new district, it does have strict scrutiny. So the compelling interest of you going along and trying to fulfill the law is not there. It wasn't met. And so therefore, it's unconstitutional. It's not necessary, and states don't have to do it. So states, if you want to redraw your maps, you can do so, but you do so not on the basis of race, because that's no longer necessary to comply with this law. That's essentially what the decision was. And so now states are going to go about redrawing their maps without regard to race. It's not saying that the Voting Rights Act of 1965 is going to be overturned. That wasn't the issue. The issue was gerrymandering on the basis of race constitutional? That was the issue. So we have to be very careful, right? I do not see Jim Crow returning to the United States. I think that is hyperbolic. I think that is very abusive for many commentators to say that and very inappropriate. What I see is that race is no longer a factor, no longer a prevalent factor in how states go about drawing their maps. And it's no longer an issue. The historic discrimination that we saw in the 19th and 20th century is no longer here anymore. And so these unconstitutional measures that Congress and the Supreme Court had to apply are no longer necessary anymore. And so we can put those away. And I think this is a triumphant time for us as Americans to pat ourselves in the back that we were able to get over our dark past and we're moving forward to a brighter future. So I think that the decision that the Roberts Court made was appropriate, and I definitely agree with it. And that's just my opinion.